The topic for today that we are going to discuss is licensing of e-content and fair use of open educational resources. When we talk about educational resources and fair use of educational resources, let us first start with some foundational learnings. Let us first start with an understanding of what a copyright is. What is the purpose of a copyright? Why do we need a copyright regime? How has copyright laws how have they evolved, and what is the meaning of copyright, right? The purpose of copyright is to encourage and incentivize creators, right? What does that mean? It means that creators, when they create some work, copyright protects certain rights that they have, exclusive rights that a creator has with respect to their work, and encourages them by protecting those rights so that there is an incentive to create more work, ensuring that creators receive economic benefits of their work and promotes innovation and creativity. So the purpose of copyright then is twofold. One is for individuals or creators to create work so that there is economic exploitation of that work. And secondly, for the society in general, by encouraging creators to create work, the society in general benefits as new and new creations take place because of the fact that they can be exploited economically. How did copyright come into being? Why do we need a regime of copyright? Since the very advent of humanity, since the very beginning and till today, the way we develop information, the way we store information, and the manner in which we communicate and access information has changed a lot. The very first aspect that led to a copyright regime or a need for a copyright regime was the printing press. The printing press meant that earlier, if you had to copiously write down things or write down a manuscript in order to copy it, now it could be done in much lesser time and much lesser resources. This led to a need to protect the right of the authors and the owners of the particular work. And that led to the first statute in the UK known as the Statute of Anne. Since then, various developments have taken in the international sphere, which are listed here. Most importantly for India, the law that today governs copyright, law relating to copyright, is the Copyright Act of 1957. It has been amended from time to time. Prior to that was the Copyright Act of 1914, which was modeled somewhat on, to a great extent, in fact, on the UK law of 1911 with respect to copyright. Today, copyright law needs to not only address the challenges that were created by advent of printing press, but also somewhere address the challenges that are now coming up with more and more means and ways by which information is stored and disseminated. If earlier some parts of our life were recorded and could be communicated to the public, we are in an age where absolutely every significant part of our life is today, without any time in between, is immediately recorded and sent to public, whether it is through Facebook Live or any kind of live communication website or Insta Reels, that immediately any significant aspect of human life can be communicated to people. So what is a copyright? What right does a person have by virtue of owning a copyright in a work? A copyright is not just one right, but is a bundle of rights or a packet of rights. What are these rights? These rights are essentially economic rights: a right to make copies of a certain work, a right to reproduce or make copies, to sell or issue these copies to people at large, to perform the work in public and communicate such a performance to the public, to make a cinematograph film or a sound recording on based on the work, to translate the work and to adapt the work. A copyright is not just a right to do those things with respect to a certain work, but it's really a right to not let others do those actions with respect to that work. What does that mean? That in case the right of the author or the owner of the copyright, in case of commissioned work or in case of an employer, is not only with respect to doing certain things, but also stopping others from doing certain things, right? And then there are also moral rights, which are independent of the economic rights and which are enjoyed by the author. When we look at teaching and use of materials, there are certain misconceptions I feel that we all somewhere harbor and which need to be clarified. First is that reproduction for teaching is permissible use, that copyright per se is not applicable at all to teaching. I've often heard people saying that if I'm doing this for the purpose of teaching, I am a teacher and therefore copyright does not apply to the work that I use in terms of instructions or teaching. The 10% rule, I don't know if you have heard of the 10% rule, but I've heard of a rule that people say that if you copy about 10% of a certain work, then you are in the safe zone, then you are not infringing on any other work. The one chapter rule, if you copy just one chapter of a book, then you are in the safe zone, it's not an infringement. A very common misconception is if it's on the internet, it's free to use for all. As an academic, I can use any material from the internet without a license. For teaching or non-commercial use, I need not give credit to the author. It's fair use because I give proper attribution, conversely, right? So what questions that this brings up is, how much of use in terms of educational use can be termed as fair use or fair dealing is a very natural question that will come to your mind. Second would be, which material can I use? Is there a category of material that I use with or without a license, which can be used under the act and it will not amount to infringement of the original work? Is the nature of use important? Does it matter that it is for the purpose of teaching? Is it for the purpose of non-commercial use? And is it important or necessary to give credit to the author? Is it necessary to give attribution to the author? These are some of the questions that we will be exploring in the further aspects of the presentation. When we talk about education resources, for the purpose of this presentation, I've broadly put them into these 4 categories. What are these 4 categories? First is licensed work, licensed under the Act, a specific license for use of that work. Second is unlicensed work, which would come within the purview of Section 52. Third is open educational resources, where these resources are free to use for all. This category, a subset of it would probably fall in licensed work, and subset of it would fall in public domain. For the purpose of this, we'll look at open educational resources objectively and resources in public domain. Before we go to fair dealing in the context of educational resources, we will quickly have a look at licensed work in terms of the Act. Licensed work in terms of the Act here refers to a specific license which is granted under the Act for the use of that work for a certain purpose for which it is being used. This license would be under Section 30 of the Act and given voluntarily. Such a license may have a time limit to it. It may be an exclusive license or a non-exclusive license. In such a case, if there is a license to use the work, it will not amount to infringement, and we will not discuss this further for the purpose of this presentation. The second is unlicensed work. Unlicensed work is work where no specific license has been obtained from the owner of the copyright by a person who intends to use it as an educational resource. Can such work be used? And if such a work is used, to what extent can it be used? In what circumstances can it be used? And would that amount to infringement? Fair dealing in terms of licensed works, we will look at fair dealing. Fair dealing is in Hubbard versus Wasper. Lord Denning had said that it is impossible to define what is fair dealing. It must be a question of degree. So it is not possible to put it in a certain box or to have a straitjacket formula as to what is fair dealing. But in order to understand what is fair dealing, we must first understand what is the purpose of fair dealing. Why do we have provisions of fair dealing? Copyright law somewhere balances the rights of individuals, rights of creators and owners of copyright to exploit economically the fruits of their creation. But at the same time, access to education or access to that material is also an important aspect of copyright. Fair dealing is an exception or a limitation to the general rule of copyright. In fact, I would say that fair dealing is as important as copyright itself. In order to maintain the balance in the society, in order to incentivize creation, it is equally important that works which are protected by copyright are available for certain purposes. Where do we find the word fair dealing in India? Where do we find it in the Act? The words fair dealing, the term is used in Section 52. For education, the Act enumerates these exceptions to the general regime of copyright, the general rule that any use beyond that of the owner which is not licensed will amount to infringement of the work. The first is for private or personal use. Please note the wording here. 52A says fair dealing in private or personal use, including research. Second is criticism or review. And third is reporting of current events and current affairs, including lecture in public. Now, the very term, the way the wording is, it says fair dealing in. So it is not enough that it is a private or personal use, but there is something more that is required than merely falling in 1, 2, and 3. And what is that? That there must be an element of fairness or fair dealing in that. We will quickly look at the other two provisions of the law. Section 52(1)(I) says publication for instructional use capped at 2 passages per author per publisher. Please note the words here, publication and instructional use. And this should be H, not I. And see the next aspect, section 52(1)(I), which is reproduction by teacher or pupil in the course of instruction, or B, as part of question or answers in an examination. What this tells us is that the statute has used words publication and reproduction in H and I, which are different to each other. The meaning of the word publication and the meaning of the word reproduction is different to each other. So how do you determine whether a certain use is an exception as carved out in section 52 or not? The easiest answer would be if it falls within the exceptions which are carved out in section 52. However, although the exceptions in section 52 are exhaustive in nature, there is no definition or there is no criteria that a certain use will clearly fall in section 52A fair dealing if it is so, if it conforms to certain norms. And therefore, we have to look at what are the tests of fair dealing or fair use. You must have heard the term fair use and fair dealing, which is often used interchangeably colloquially. Nonetheless, there is a subtle distinction between the two. Fair use is the term which is used in the US copyright law and has a 4-factor test. Whereas that 4-factor test, as on today, we have not accepted in the Indian jurisprudence. Fair use under the US law is a 4-factor test that I'll just read out those 4 factors to you. What are these 4 factors? One is the purpose and character of use, including whether such use is commercial or is for non-profit educational purpose. Very important. What is the nature of the use? The courts will see. Is it for a non-commercial purpose? Is it for non-profit educational purpose? Or is it for commercial purpose and for profit commercial educational purpose? Right? Second is nature of the copyrighted work. What is the work? What is the original copyrighted work of which infringement is claimed? Third is the amount of sustainability of the portion used in relation to the copyright work as a whole. What is the quantity and quality of the work which is used in terms of the whole work? So is it, probably that is why people say 10% of the work, but there is no such number which has been enumerated. And fourthly, the effect test, the effect of use upon the potential market or value of the copyrighted material. What is the effect on the market of the owner? So as a copyright owner, if I expect to receive certain monetary benefits or to exploit a certain work in a market by the causing of the infringing work, how is it? What is the effect that is caused upon the market? This is the 4-factor test which is developed in the US jurisprudence and thereafter codified in the US Act. What about India? In India, is there a test like that? The Indian case laws have referred to the 4-factor test. However, in Rameshwari photocopying case or the DU photocopy case, the court has categorically held that the law in the US and the provisions of the law in India being different, it is not possible to take the test as it is, especially the aspect with respect to quantitativeness, and apply it to India. In India, in Civic Chandran versus Ammini Amma, a very interesting case. Here the issue was, this is a Kerala High Court judgment. Here the issue was whether a counter drama which was written regarding a play written by a well-known playwright amounted to infringement of the earlier original work. And the court there laid down 3 principles. It said the quantum and the value of the subject matter which is taken. Second, the court said the purpose for which it is taken, very similar to the US tests as well. And thirdly, the likelihood of competition between the two works. In that particular case, the court held that the drama or the counter drama, which was alleged to be an infringing copy of the original work, was not an infringement but amounted to criticism of the original drama. A very interesting case and a landmark decision when it comes to fair dealing and education in India is the single bench and the division bench judgment of the Delhi High Court in Rameshwari photocopy case. What had happened in that matter was that the Delhi University had created these course packs. What were these course packs? These were a compilation of excerpts from various textbooks which were included in the syllabus given to the students. That course pack was given to a shop, a photocopy shop in the campus of DU, and the photocopy shop was making copies of it and selling it to the students. Oxford University, the Oxford Publishing University Press at that time came up with a challenge and said that what the Rameshwari photocopy shop was doing was not permitted within the meaning of copyright law and therefore amounted to infringement. The single bench and then the division bench of the Delhi High Court held that that is not correct. The courts held that what the DU University, what DU had done was create course packs from the syllabus for the students, and therefore it fell within 52(1)(I) and not 52(1)(H) of the Act. Please see, what did 52(1)(H) say? What does it say? It says publication for instructional use and it is capped at 2 passages per author per publisher. The court said that it is not publication. Publication expects that it is publication for communication to the public at large. What this use fell into was section 52(1)(I), which is reproduction by a teacher or pupil in the course of instruction. Two very interesting aspects come up in discussion by the single bench as well as division bench in this matter. One is, can it be said that photocopying by Rameshwari photocopy is reproduction by teacher or pupil? And the second was, what is the meaning of the term course of instruction? Please note here the words used are not educational institution. It's a very wide term which is used here, which is in the course of instruction. For both these aspects, for the first one, the court considered the advent in technology. The court said there are technological advances. Earlier, a student could take a pen and paper and note down from the library whatever was in the book. A student could copy the whole chapter, 2 chapters, how much ever they wanted. With passing of time and with photocopiers, a student can now go and photocopy a certain excerpt from the book that they find necessary for their learning or studies. The fact that it is not done by hand by the student but by the photocopier will not affect the application of section 52(1)(I), and therefore reproduction by teacher or pupil will be applicable in this case. The second question was, what is in the course of instruction? A very narrow view of course of instruction is possible. It is possible to say that in the course of instruction is within the classroom only, correct? But the court did not subscribe to such a view. The court held that the course of instruction is it gave a very wide connotation to it, and it said throughout the process of the course of instruction, This also leads us to a further question as to whether this would mean that section 52(1)(I) will be applicable not only for educational institution but also in case of any other use of educational resource in a setting where there is a teacher and a pupil and there is course of instruction, right? Then we look at what are open educational resources. We looked at what is a licensed work, we looked at unlicensed work, and we saw that unlicensed work can be used only when there is fair dealing, fair use provisions in place, or rather in terms of Indian law, if it falls under permissible uses under section 52 of the Indian Copyright Act. What are open educational resources? The Universal Declaration of Human Rights in Article 26 and Article 13 of the International Covenant on Economic, Social and Cultural Rights states right to education as a very important aspect of human rights. Similarly, we are all aware of the Sustainable Development Goals, and One of the Sustainable Development Goals, the fourth SDG, refers to access to quality education as a goal to be achieved till 2030. With all this in mind, the UNESCO General Conference at its 40th session has in fact adopted recommendations on OER, which is a policy document on encouraging use and development of OERs or open education resources. What are open education resources? Open education resources are resources to be used for educational purposes, which are free to use for all. The 5 R's of OERs, as they are known, the first is reuse. That is to say, it can be used openly without requiring a separate license for the same. Second, retain. That is to say, store, make copies of it, keep it on the computer, take a hard copy, keep it with you. Third is revise. Make changes to the work as it is available. Remix. Make changes again, but by adding something to it. And fifthly, to redistribute. That is to say, to share. In a country like India, where students' right to education is also a fundamental right under the Constitution of India, and where students may not be in a position to buy expensive textbooks, it can be difficult to get access to education and good quality education. And therefore, the aim of open education resources, particularly for developing countries, is to ensure that the costs of education, either for a student who intends to access textbooks or other learning material, or for teachers who have to pay considerable costs to create teaching materials, is reduced. If the teachers who are able to access open education resources for the purpose of creating further resources for their students, it will ultimately percolate. The expectation is that it will ultimately percolate to the students in terms of cost benefits. Open education resources then are with an aim to ensure access to all without specified requirements, without a requirement to get a license. The most common of open education resource license in terms of licenses that are issued on the work itself. How do you know? For example, how do you know that a certain resource is an open education resource? So one common way of identifying is to look at the work itself. And usually a resource which is open education resource would have a Creative Commons license on. A Creative Commons license consists of various permutations and combinations of these 4 signages. Let us look at these signages. What is the first one? By. All creative licenses would have this first signage, which goes by the identifier by. This means that the credit must be given to the creator. No Creative Commons license requires or rather stipulates that the work can be used without attribution. Attribution is one of the bases of a Creative Commons regime. Second is FA, share alike. What it means is whatever adaptations are made under the work should be shared under the same terms. NC, the third one, is non-commercial, which means that the use of that work is permitted only for non-commercial purpose. And fourth, which is ND, no derivatives or adaptations. The work may be used as it is, but it cannot be adapted to another format, or no derivatives. The work cannot be improved upon or changed into another derivative work. With various permutations, combinations of these 4 signages, these are the most common 6 Creative Commons licenses. The first is CC BY. This is the most permissive of licenses. This means that a person may use a certain work, but by giving attribution to the creator. In terms of use, the user may use it, a user may retain it, a user may retrieve, all the 5 R's, right? The second license is CC BY NC, which means Creative Commons attribution and non-commercial. A user may use the work but may not exploit it for further non-commercial use. CC BY SA, which is a user may use the work, attribute, but share in a similar manner on the same terms as the original work is shared. CC BY ND, which is a user may use it, attribution, and non-derivative. The user may not adapt it further or may not create any derivative work based on the original work. Fifth and the sixth license is a combination of 3 signages, One is non-commercial, non-derivative. I think the names themselves are clear enough. And NCSA, which is non-commercial and share alike. That is to say, a user may use it, may adapt it, but can only do so for non-commercial use, and he will have to share it alike on the same terms further. One aspect of Creative Commons licenses is that they cannot be revoked. So, for an owner of a copyright who wants to put their work within these 6 licenses, it's very important to think it through, as it cannot be revoked afterwards. One more thing as a user that one needs to look at is who has granted the license on the work. So it's important that the person who has given the license, whether it is a CC BY license or CC BY ND license, that person has the authority to grant that license. So he must be an owner of the copyright to have the authority to grant that license. Having looked at licensed works under the Act, unlicensed works, open education resources, I think the fourth category of works is the works in public domain. How does a work get into public domain? Either on expiration of copyright under the Act, or if the owner himself or herself has put it in the public domain. Section 21 of the Act provides for relinquishment of right. So by it is open for an owner of a copyright to relinquish their right by following the procedure which is given in the Act. What does that entail? What does it mean when a work is in public domain? What does it mean when the copyright in that work is no longer valid? What it means is that a user who has access to the work may use the work in whichever way they want. They may adapt it, they may share it, they may translate it, they can do whatever they want with the work that they couldn't earlier do because the owner had a copyright in it. But does that mean that the author of the work has no right at all? Is it permissible for me to take a work which is in public domain and put it and communicate it or put it on a website as my own work? No, that is not the case. The author retains his moral rights. One aspect of the Copyright Act and after the amendment, Section 57 of the Copyright Act, is that moral rights are independent of the economic rights. Moral rights of a certain author do not travel with the economic rights that he owns. So a person who has moral rights has a right to be given attribution, a right that his work may not be destroyed, right? So even for a work which is in public domain, it is not permissible. It is not permissible for me to take Shakespeare plays and publish them as my own. And so, although work may be used, proper attribution, whether it's a Creative Commons license or a work in public domain, is necessary. This brings us to certain questions that need to be answered going forward. The way we learn now, especially since the pandemic, has had a massive change. Gone are the days when traditional educational institutions were the only means of learning. Today, learning, even in traditional educational institutions, is no longer in the same lecture setting, classroom setting, and it has changed a lot. It has evolved over time. And this brings us certain questions about use of these materials in these new settings. Is our law equipped to deal with the challenges that come with virtual learning? I think the first and foremost question that one needs to answer is, are provisions or are exceptions of fair dealing which are permitted in Section 52, are they also applicable to non-traditional educational institutions? Are they applicable to, if you recollect, I had highlighted the term in the course of instruction in Section 52(1)(I). So the question today is, and that probably will be answered sometime in the future when this comes up before the courts, is, are these exceptions applicable to other forums of learning? One way of answering this is that there is a very wide interpretation of the term course of instruction by the division bench of the Delhi High Court in the DU photocopy case, and therefore that will be applicable, and all such forms of instructions where there is a teacher and pupil relationship can be established, whether it is education for profit or not profit. So long as there is instruction, the exception which is laid down in Section 52 will be available. and it will not be an infringement of work. So that essentially means that any copyrighted work, especially after the DU photocopy case, any copyrighted work could be used by other than traditional educational institutions as well. This would have a very far-reaching impact, especially on the rights of copyright owners and publishers, and therefore this is something that needs to be settled sometime in the future. The second question that comes to our mind is, what are the implications for an educational institution? What if the material which is shared by the institution is further shared by users? So at an age today where most of our learning is digital, most of our learning resources are stored in a digital format. What is the implication if these resources are further shared by, say, students, or if a lecture is recorded and then shared by students? So is the institution under any sort of liability, or is it a duty of an institution to ensure that the material is shared in such a format that it is difficult for end users to share it further? And thirdly, another question that comes to my mind with respect to virtual learning is, can a lecture that contains copyrighted work be stored on a platform with access to students and others? To a certain extent, this is answered by section 52(1)(a), an explanation to that, which says that a lecture which is delivered in public can be stored digitally. Nonetheless, when a lecture which is delivered for the purpose of students of an educational institution uses some copyrighted work, can it be stored by the educational institution where there is access to students, and not only students but others as well? Will be a question that will have to be answered. In terms of fair use of copyrighted material, in terms of use of licensed work, I think the law is still evolving, and there are many questions that will come up in the future as we move to more and more online learning. But it will only time that will tell us the way the law evolves, and it will clear the position for us in India. Thank you, everyone.
There's one question, ma'am. What do you mean by traditional institutions?
The word I've used, traditional institutions, today is in terms of educational institutions which are, say, accredited by an accreditation agency like UGC or. But today the way we are learning is not only through schools and universities and colleges, right? We also learn through various other means. A coaching class may not be a non-profit education institution, and a question might come up as to whether, in terms of a coaching class where there is instructional discourse, whether the exception or the benefit of section 52 can be granted.
Okay.
One question here which says, does it amount to infringement if publisher published in absence of a contract? It is, and so as we discussed earlier, a copyright is a right to copy, firstly, to create copies. And if a publisher publishes something without a license or an assignment of rights from the owner of the copyright, then it will amount to infringement. But essentially, NFTs will not really. I think today we are constraining ourselves to a discussion on education and copyright, and what amounts to, in what circumstances can teachers, trainers, and students can use copyrighted materials without inviting action of infringement against them, which is why we will not go to NFTs today.
If a professor in good interest shares the material with the students, will it amount to infringement?
Yeah, that's the point, isn't it, Komal? That's really the doubt that teachers usually have or students have. Can you share whatever is available to you with your students or not? And I think the way the trend in Indian judiciary is to it tilts towards educational use of copyrighted material. As we see in the DU case as well, it does seem that the trend is tilted towards use and permissible use of copyrighted materials. But having said that, it is not what needs to be then seen is what is the material which is shared. The 4-factor test that was laid down in the US may not directly be applicable, but it will be important to see as to how much of the material is actually shared, whether it is a copyrighted work. If it is a copyrighted work, is it or is it not something which is permissive? So there is, I think, the difficulty with fair use and the confusion. It's tricky. Fair use is tricky. There is no clear benchmark of this is fair use and this is not fair use. Therefore, I said in the initial part of the presentation also, there is no such thing as 10% use is fair use. A professor can share 10% and he is safe, or he can share one chapter and he or she is safe. It doesn't work like that. So I think what is important also is to see, is the use excessive or not? Is the use too much? If it is in the course of instruction naturally and it is not excessive than what was the intent of that class, it may be protected.
Okay.
In absence of the contract, whether published material is an infringement. You said yes. The contract was, the request was met to the author, but certain conditions were not agreed to, as you were pointing out certain conditions. And that's why the contract is not signed, but they went ahead to publish the material. So
Okay.
It will be treated as an infringement, right?
Generically, if a person has a right in a certain work. So, for example, you are saying that a publisher has published it. So, say, for example, you write a book, right? And you are the owner of a copyright in that book. So, no other person can make copies of it and sell it without your consent, right? Without a license or an assignment. In fact, either you transfer your ownership to them, or you give them a license to publish this. But it will also, in the facts of the matter, it will also have to be seen for what purpose it was published, whether it was actual publishing or not, and other aspects.
And in that case, if there is a question mark in that case, the next edition author publishes with a lot of modifications. In that case, the old material, does it then help the author in claiming that the old material is an infringement?
How old is the old material? So is it beyond? Has the copyright in that has expired? Is that what you are suggesting?
Now that question, how is there an auto expiry?
No. So see, the term of the copyright is what is determined by the Copyright Act. In most literary works, it is 60 years from the date of the death of the author.
Okay.
Correct. And for cinematograph films and such, it is 60 years from the calendar year, the next calendar year from when it is actually published. Okay. So that is the term of the copyright, which is already laid down in the Act. The copyright will not expire on its own prior to that. Prior to that, if the copyright has to be extinguished, that will be only if the author himself relinquishes the rights as it is laid down in 21 section of the Act, but not beyond that.
Agreed. Okay. Thank you.
Thank you so much.